the petitioner is allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions mentioned in the order.
Public.
Lordship, CD not receiving this matter. Interim is there.
Interim is there.
Yes, Lords. Otherwise, my lord, we have appeared before the IO, my lord.
You have appeared.
My lord. And statements have also been recorded, my lord. The allegation is, my lord, lending of money at exorbitant rate. That is the allegation. Lost by a policeman, my lord. But interestingly, my lord, that Assam Moneylenders Act, that section has not been attributed, which is bailable in nature.
What is to be done? Should we await for?
Because he is in interim, it may be extended also.
Okay. Heard Mr. N.J. Das,
Right.
learned counsel for the petitioner. Also heard Mr. K. Bocho, learned additional public prosecutor, who submits that though the case diary was called for, however, same it has not arrived, and prays for some more time for producing the same. The prayer is allowed. Let this matter be listed after.
Lordship, 12th.
On 12th of June, the interim order shall continue till next day.
I'm DPO.
One of these matter relates to the cancellation of the bail. Your lordship call for the record also. And other side is also today again absent. They filed the affidavit, we have also replied. Not replied, it is in the record now.
Yes. Where is the counsel for the?
Very difficult to say.
He's sitting in the bar.
But in the bar, I have seen him.
Yes.
In our same room we are.
Mrs. Yes, Mr. Ali. Yes, Mr. Vishas, what is your ground? Why have you filed this interlocutory?
Our ground is that they have suppressed the fact.
What?
Which is the requirement of law that whatever might be the consequence of judgment or order
Oh.
or bail granted or rejected, he must mention. He has completely not mentioned in the petition.
Regarding rejection of earlier,
Yes. And your lordship was kind enough to be convinced, on being convinced by his submission, granted the bail. And in this case, respect my latest judgment of 2023 Supreme Court, my lord, Kushad Daruka versus State of Odisha. Very famous judgment in this, what is the consequences of suppression of facts.
yeah,
And our High Court rules also doesn't permit it. So we pray that his bail may be cancelled, madam.
yes. Mr. Ali.
My lord, we have filed, my lord, our reply, my lord. First, our submission, my lord, the instant petition, my lord, is not maintainable. Because the signatures of the applicant, my lord, is different in every case. They have not countered, they have not filed any reply, my lord, clarifying the stand.
No, no.
Now,
Signatures means?
signature of the complainant, my lord,
In the Ukalatnama.
in the FIR, Ukalatnama and my lord, affidavit.
My lord, record before your lordship,
They have not, my lord,
see it.
they have not, my lord, filed any reply to that.
No worry, what is twice.
Okay. Okay.
Now, secondly, my lord, there is, my lord, So, my lord, they got sufficient time, my lord, they have not made any clarification or deny our allegation.
What is your allegation?
That this petition is by proxy war, my lord.
Okay.
Now, second, my lord, on merit, my lord. The FIR, my lord, filed, my lord, on 15/2/2023. Altogether 37, more than 37 persons named in the FIR.
Where is the FIR at page?
At page, my lord, in their petition, my lord, page 12, annexure A. Hmm? Huh?
Yes, what is your submission?
Now, my lord, 37 persons, my lord, named in the FIR. And in the FIR, my lord, there is no direct allegation against us. We, my lord, along with others, approached this all court in the initial stage. Before filing charge sheet, my lord, our bail petition was rejected. At the initial stage, on the ground that investigation is going on
By which court?
by the court number 13, my lord.
This court, High Court?
No.
High Court.
Lordship, by this our court.
When it was rejected?
It was rejected on, my lord, 27/4/2013.
This was within.
AB
this-
number 741/2023.
Yes.
And AB 721/23 on the same date, my lord.
Thereafter,
Thereafter, my lord, during investigation, my lord, the police did not search us. And after, my lord, completion of the charge sheet, my lord, because we are not prime accused in the case, we are the relative of the prime accused. And during investigation, my lord, police did not make any search. Subsequently, my lord, after completion of search investigation, my lord, charge sheet submitted. Charge sheet submitted showing us as absconder. Charge sheet submitted on 5/5/2023. 15/5.
thereafter,
In the meantime, my lord, prime accused, my lord, they surrendered 13 numbers of accused surrendered. They also approved this all court, my lord. And this all court, after, my lord, charge sheet was pleased to grant them bail. And case fixed for appearance, my lord.
what is the case number? In, now case is pending before,
Before the trial court, my lord.
is it sessions tribal case?
Session tribunal, 302 cases.
Now it is pending before committal court or
My lord, in the meantime, my lord, the latest information I don't have, my lord.
it
Because
is,
a copy has already been furnished on the last date,
all have appeared.
lordship. And in terms of the order also, my lord, other accused, my lord, also appeared,
You have appeared before the trial court.
trial court. So there is a difference between, my lord, prior to
You appeared before the trial court when the bail was granted by this
lordship,
court.
lordship. Because as we have been shown as absconder, my lord, we approach the small court, that we are ready to appear before the learned trial court. As 302 is there, my lord,
Where is the order? Bail order
bail order, my lord.
by which bail was.
Page 30, my lord. Page 30. Our specific, my lord, submission that we are ready to appear as we have been shown absconder, my lord. And 322 is there. So learned trial court may not be released us on bail on our appearance. Therefore, your lordship granted my lord conditional bail, page 30.
What bail was granted to you?
Lord, your lordship directed us to appear before the learned trial
No.
court.
Is it a regular bail or an anticipatory bail?
My lord, we have filed my lord under section 438. Because 439, my lord,
It is anticipatory bail.
lordship. Because
So
our 430
So in person to the direction of this court,
lordship
the trial court granted you, allowed you to go on bail.
on bail. And we are cooperating with the trial, my lord.
But you suppress the fact that you
My
were,
lord, intentional suppression is not there because, my lord, earlier rejection was, my lord, before, my lord, charge sheet. And second
No,
application, my
but
lord,
the law is clear.
lordship.
The rejection, earlier
We
rejection.
ought to have mentioned, my lord. And
Well-
exactly in similar case, my lord, the Honorable Supreme Court, my lord, also, my lord. Here also, my lord, rejection was, my lord, first rejection was not brought to the notice of the Honorable Court. And Honorable Court granted bail. Cancellation was filed. On this ground, bail was cancelled.
Bail
Honorable
was cancelled. Okay.
Then, my lord, Honorable Supreme Court, my lord, set aside the cancellation order, my lord, saying that,
On what ground?
Lord, that although, my lord, it was rejected in the initial stage, my lord, exactly similar situation, my lord.
No, on
And-
what ground the cancellation order was quashed by the Supreme Court? Where is the relevant paragraph which you are denying?
Small judgment, my lord.
Mr. Vishwas,
Paragraph 7.
your main submission is that they have suppressed the. that
Rejection
is-
of earlier.
Yes.
Suppressed the rejection of the
Yes,
earlier
I
order.
have
That is
connected
the only-
that.
that is
All
the
have been rejected in.
They have not followed the High Court rules
Yes.
and they have made, whether they made any statement in the
no, no.
affidavit.
Had there been any mention of any statement, that matter would have been different.
No, what was the affidavit in their bail application?
They have also, no bail was pending or filed earlier.
So that is a false statement.
Yes. This is the latest of 2023 Supreme Court regarding
Yes,
suppression.
Mr. Ali, regarding the affidavit which you have filed along with your earlier bail application, that what is your submission regarding the affidavit which was filed along with the.
This is, my lord, bona fide mistake, but otherwise there is no impact, my lord.
No, no,
Because, my lord, after charge sheet, my lord, and-
you are deposing something on oath
lordship.
that no earlier bail application has been filed. But what is your submission? I just want to know about your submission. What is your stand? That on affidavit you said that there was no bail application has been filed or rejected. And it appears that you were aware that in the initial stage, an application was rejected,
Lordship.
but you have not mentioned, rather you have mentioned that no application is pending or rejected. What is your stand on that?
My lord, this, my lord, unintentional omission, my lord, because otherwise, my lord, there is no impact on merit, because we are ready to surrender before the trial court. And your lordship also consider on that point also,
Which point?
that we are ready to appear and trial, ready to face the trial.
No, question here
And
is,
prime accused has already
when you
appeared.
make false affidavit before court,
Lost.
can you get the benefit of the
Now,
law?
Lordship, I am relying this judgment, this recent judgment, 2024 judgment.
Yes, what it says, which paragraph you are relying?
From paragraph 4, my lord.
Kavita Pal. Which
Lordship.
paragraph?
Lordship kindly consider paragraph 4 also, my lord.
Yes,
It is also a matter of record that instant applicant so-and-so, the mother of the prime accused, move application seeking anticipatory bail. Firstly, before the session court, thereafter before the high court, which was undisputed, stood rejected. This was all before the filing of the charge sheet, dated so-and-so. It was a matter of record that post dismissal of the application on so-and-so, the instant applicant appellant again applied for anticipated bail before the High Court, which stood allowed by the order dated so-and-so. The complainant, by filing application under section 439(2) CRPC, sought cancellation of such order, which stood allowed by impugn order dated so-and-so on the ground that instant appellant has suppressed material facts of dismissal of her previous attempt to secure bail application. The appeal thus arise of such order of cancellation granting anticipated bail. At this juncture, we may also note that this court by order dated so-and-so has granted interim protection in favor of the accused, subject to all cooperating in the investigation and trial. Before us, it is not in dispute that the instant application is full compliance with such order. It is not a case of the respondent that post-grant interim protection of appellant has in any manner impeded the cause of justice. The concept of anticipated bail came to be part of criminal law landscape where so-and-so recommended the inclusion of such provision, which the institute incorporated in CRPC. Over the year, many judgments of this court have considered that court must wait while considering the application for anticipated bail. The fact must be borne in mind while considering the application for grant of anticipated bail have been enunciated in the decision of this court in so-and-so. Now, my lord, paragraph 7, my lord.
yes.
On perusal of the records revealed that prime accused, namely so-and-so, have been charged under so-and-so. He has been granted anticipated bail. Present appellant has been charged under section so-and-so. It can be seen that alleged act of instant appellant is inextricably bound to be act by prime accused. It is alleged that he had secured picture of complainant that were compromising nature, which then instant appellant used to extort and blackmailing the complainant. While granting anticipated bail to prime accused, the learned district judge has observed that it was not fit case for custodial interrogation. It has not been brought to our notice that such an order of anticipated bail has been challenged, and if it has, what fate it met, then it follows the secondary accused would be not required in attending facts and interrogation of custody. Grant of bail based on parity is not a claim of right. Same is well established. While applying this principle in parity, the court is required, as was recently observed in so-and-so, this court required to focus on the role attached to the accused whose application is under consideration. In the facts, prime accused who is alleged to have initially conducted the blackmail whom the complainant is said to have paid hush money has been granted bail, and the role played by the instant application was only further the alleged act of her son. She has not acted independently or further aggravated of situation. In the view of the matter, we find it fit to confirm the order dated so-and-so granting anticipated bail to the instant applicant, setting aside the cancellation order filed by division bench by the impugned judgment order.
what the Supreme Court has observed regarding suppression of the earlier fact? Any observation is there?
My lord, there is no such direct, my lord, observation in this case, my lord. Here also, my lord, the prime accused, they have surrendered. After 90 days, my lord, they released on bail by the Sound Court.
They got default bail.
No, my lord. Because after charge sheet, my lord, the Sound Court granted bail. And after this order of the Sound Court, my lord, all we appeared, we are, my lord,
Okay, okay.
regularly
Mr.
attending.
Vishwas, do
Yes,
you
sir.
have a copy of
So
this judgment?
They will not be prejudiced in any manner, but because
No.
investigation has already been completed, my lord.
Question of prejudice doesn't arise.
What is your submission counter
Thing is
to?
that if your lordship, we pray before lordship to intervene in the matter. Otherwise, it will become a law. It will become a precedent. Everyone will cite.
What is your submission?
My submission is
regarding
that-
the- Regarding the judgment cited by the,
Yes, kindly come to para 20 of my judgment, Supreme Court matter. I have placed to your lordship, my lord, Kusho Daruka versus State of Odisha,
para 20.
20 by. In our opinion, to avoid any confusion in future, it would be appropriate to mandatory mention in the applications filed for grant of bail. What? Details and copies of the orders passed in the earlier bail application filed by the petitioner, which have been already decided. Details of any bail application filed by the petitioner, which is pending either in any court, below in court question or higher court, and if none is pending, a clear statement to that effect has to be made, which is absent here. Then, my lord, the court has already directed by past order in Pradhani Jani's case Supra that all bail applications filed by the different accused in the same affair should be listed before the same judge, except in cases where judge has superannuated or has been transferred or otherwise incapacitated to hear the matter. The system needs to be followed meticulously to avoid any deficiencies in the order. In case it is mentioned on the top of the bail application or any other place where it is clearly visible that the application for bail is either first, second, or third, or so on, so that it is convenient for the court to appreciate the arguments in the light. If this fact is mentioned in the order, it will enable the next higher court to appreciate the arguments in light. The registry of the court should also annex a report generated from the system about the decided or pending bail application in the crime case in question. The same system should need to be followed even in the case of private complaints, as well as all cases filed in the trial court are assigned specific number, even if no FIR number is there. It should be the duty of the investigating officer or any other assisting the state counsel in court to apprise him of the orders, if any, passed by this court with reference to different bail application or other proceedings in the same crime case. And the counsel appearing for the parties have to be conduct themselves truly like officers of the court. Our suggestions are with a view to streamline the proceedings and avoid anomalies with reference to the bail application being filed in the cases pending trial and even for suspension of sentence. Though considering the conduct of the petitioner, one of the option available was to cancel his bail. However, we do not propose to take such extreme step in the case in hand. However, this can be option exercised with the court if the facts of
where
the
are
case
you reading? Which para?
22. Considering the conduct of the petitioner, one of the options available was to cancel his bail. However, we do not propose to take such an extreme step in the case in hand. However, this can be option exercised with the court if the facts of the case so demand, seeing the conduct of the parties. The present appeal is accordingly dismissed as infructuous. However, still we deem it appropriate to burden the appellant with a token of cost of rupees such and such, which shall be deposited him with Mediation and Conciliation Center attached to Odisha Court, High Court, within a period of 8 weeks from today. So, my lord, this is the
So
guidelines.
here cause was that via media was out. Here,
But
here
By
also,
this judgment, the streamline has been made, my lord, so that, my lord, in future, my lord.
but your
Lost.
case is after this,
After
No,
this
no,
judgment.
no, no.
this judgment.
The 23.
Judgment কবে হয়েছে? এটা
Yes,
recent
but-
judgment. Recent judgment, my lord.
No, this judgment is dated,
Lord, case was of 2023. I have gone through only 2024, my
No,
lord.
our High Court rules also is there, man.
If I'm not wrong, my lord, disposed of recently, my lord.
There was a difference, yeah.
I have
January 1920.
It is January 19, my lord.
okay, okay,
24, recent judgment.
okay.
And thereafter-
Yes, Mr. Basho, what is it?
Thereafter, this,
All this matter of record. when we
No, no, but your submissions regarding
this is my lord, bona fide
regarding
mistake on our part.
violation, no, I have heard
Lost.
yours.
I'm sorry.
There is it appears that there is a wrong statement on affidavit. But it also appears that the accused all other accused are on bail. And they are facing trial.
Here, my lord, 8 accused persons are there, rejected bail earlier. 8 accused persons. Double murder. We have lost 2 of our brother.
And they have killed.
You have killed 2, we have killed 1.
No, after one query,
Yes.
whether they have done anything else, have they threatened the witnesses?
No, my lord, that I have got information from my client. My lord.
What charges are under? Which,
302, my lord.
302.
only
Prime-
302
No, no,
or
prime charge
30
is, prime charge.
They started
302 and 34.
34.
Others are also.
Any else?
34.
Any other provision?
Very section of
Yes, yes.
Try to find. That will be perfect. Constitution.
This, আমার bail petition ও দরকার, sir.
Which one is the court?
Which court?
Which sections court?
বরপেটা, my lord.
Additional
Okay.
district or district?
Commit করা
And
হয়নি
how
কি?
many?
Commit kora nahi.
না, ভাই।
Not yet committed.
Not
I
yet.
think it is, copy has been served last date. So commit,
Copy of this served by the committal court
How many have made false statement? How many accused?
for 8 accused.
You are praying for cancellation of 8 accused?
Yes, I have given one mistake. May kindly see,
Okay,
kindly see my application.
I'll go through.
Page 28, kindly see.
Okay, let me
Page
go through
28.
the,
Rejected.
there is a probability that
Huh?
if Mr. Bisha's prayer is rejected, I am only saying a probability, then you may have to pay cost, heavy cost. You may not be allowed to go scot-free by giving, or his petition may also be allowed also. I have to go through the materials.
The judgment we have annexed, all are rejected except one.
326 also there.
326 also there.
Similar benefit the petitioners also get after charge sheet, my lord. They have been shown as absconder.
No,
They
but
also-
they have not made.
We have
false
not
statement.
made SARS, my lord. They are running after us. We are not running after them.
Heard Mr. S. C. Bishas, learned counsel for the petition applicant. Also heard Mr. R. Ali, learned counsel for the correspondent number.
What case number?
It was asked. Right.
22, 3, 24. Number case.
Especially petition 14056.
Correspondent number 1, 2,
20, 23.
one, 2. 1 to 9. Also had Mr. K. Bushra Lanet, additional public prosecutor for the state of Assam. Let this case be listed for delivery of orders on 29 May. Day after tomorrow, I will pass orders. Staple value. Up to 9.